You may be seated.
Next up is Marvel Martin versus City of Tampa. Would you like to reserve time, counsel?
Yes, Your Honor, 3 minutes if I can.
Okay, you may proceed.
Thank you, Your Honor. Good morning. My name is Brian Lee. I'm representing Marvel and Jeffrey Martin in this appeal as appellants. This case comes to the court from a summary judgment that was issued by the trial court, Judge Huey, finding that there was no duty of care. There was no duty that Columbia had to Marvel Martin while she was there, or while she was exiting the restaurant.
Let me ask you this.
Yes,
If, let's say that there was a restaurateur at a tiki bar on the beach and butted the sand of the beach. And this tiki bar served nothing in glass bottles, only solo cups. And they had their cabana boy clean up cigarette butts because it looked unsightly in front of the tiki bar. And somebody cut his or her foot on a piece of broken glass. Because any patron of the tiki bar would have to traverse the sand to get to the counter. Does that give rise to a duty in the tiki bar to make sure that the sand is safe for people to walk on?
Legally, I think it does. And the reason that is because it matters what kind of control they have over that
all the way
sand.
to the water? How far down the beach?
Right, and I know where you're going, Your Honor. The case law talks about things like ingress and egress, right, from a facility. Now, does ingress mean a mile down, from your house when you leave your house? Is that ingressing to a restaurant? Probably not. But when we're talking about a situation in this case where literally Mrs. Martin was walking out of the restaurant, Columbia, that she had just eaten lunch, that is clearly within the.
Here's the problem with that. I get what you're trying to say, which is that, look, in this case, we can all agree it was within the egress area, which albeit may not have been owned by Columbia, you're asserting was under their control in some way. The problem with that is that for us to write a reversal, on this issue, which touches on legal duty, we have to give guidance to what the law is. And so it's not enough for us to say, well, in this case, it's, because it was right in front of the door, even though it was on the sidewalk, yeah, that's close enough, and that's ingress and egress over which this defendant had control, such that there's a duty to give notice of the hazard. Other people will read into that, no matter how narrowly we write it. Other people will read into that some kind of boundary that eventually a panel has to figure out, right? Because eventually that issue that Judge Atkinson brought up and that you responded, well, it's not really a mile, but how far is it? Eventually it's got to get figured out. So how do you draw that? I mean, how do you draw the boundary line of, okay, this is quote unquote the magic words, ingress and egress into the restaurant, such that they have a legal duty imposed upon them if they're asserting control over it? Where is it?
Well, I think that you're touching on really what are the facts of the case, because courts and the case law talks about when we're talking about this kind of duty, right? And the issue of a duty is not something that is totally separate from the facts of the case.
And now you're throwing the pitch right into the strike zone, which kind of touches on this issue. Which legal duty is kind of this weird thing that in negligence law, not only do we talk about it as an issue that the court has to resolve, but oh, by the way, when you get to the jury is instructed to basically construe what duty is. And I don't think that we're going to resolve that today. But.
True, Judge, and I look very at your fellow judge because he actually had this in the case that we cited in the city of Naples versus and Joe Gass, which was my client, that case talked about this, very similar facts. And it talked about that this issue of duty, and it talked about you cannot just, as a trial court, say that because there isn't a contract or lease agreement or something that says, here's the area that you have to maintain. It's about control, and necessarily control comes into.
Let's talk about control. Could is it potentially the defendant could have excluded anyone from that area of the sidewalk? Could they have said, you know what, no one's allowed to be out here?
It's an interesting question. Sure, you have a man, Judge. The whole concept of joint control is that you have control. And so I believe the answer to the question is yes, they could have, and with any kind of establishment, if there was a hazard that was there, and there was a huge hole that had just come open, Columbia would absolutely have been able to go out there, put off tape, and say, you can't walk on this sidewalk.
Could they have trespassed someone that was hanging around on that public sidewalk right there?
It would have been an interesting conversation with the city, but that is the whole concept of joint control, is where does control for a restaurant like the Columbia start, and where does it end, and where does the control for the city start and end? When you have a situation there where there truly is a jointly controlled place, both parties have necessarily rights in that place.
Let me ask this about the control. If I, as a passerby, if there was a paver loose, I could set it back in place. So how does that differentiate me from Columbia? In other words, let's go to the ordinance for a minute. The ordinance does give rise to a duty, but that's only if the director of public works, I think it was, whatever department that was, the city, notices Columbia and says, fix this.
Right.
Absent that, and there's no evidence that any such notice was provided, we presume for the sake of this review that it wasn't. Columbia is in no different position than any other Good Samaritan who says, you know, I better jostle that paver down and to make the sidewalk flat again, or else someone's going to trip on it.
I would disagree with that, because they're in a very different situation than a Good Samaritan. Good Samaritan that comes, if you're walking down a sidewalk that you have no control over, that you don't have the duty to change things.
So doesn't that get us right back to the sand on the beach? In other words, you're going to say, presumably, tell me I'm wrong, that these people were invited to the Columbia, and in order to get to the threshold of the Columbia, they had to traverse this sidewalk with pavers. But how's that different than the beachgoers who were invited to come have a drink at the tiki bar? And how do we determine, as Judge Lucas said, how far from the counter of the tiki bar or from the door to Columbia does that duty arise?
Well, it's not just those facts. I mean, those are part of it. But the facts of this case are more broader than that, as far as the duty that they had. This was not a situation where the Columbia restaurant just had the sidewalk in front of them, did nothing on it. They just had their restaurant. What they had was an awning. They had pillars that they had put into the sidewalk. The facts and the evidence that had been adduced in the case said that they sent porters, they sent people out there to clean, they sent people out there to look for dangerous conditions. Now, they also said that, well, when we got that, we would tell the city when we had a dangerous condition. However, upon pressing, that assistant manager of Columbia said, well, the reason we do it is because we want to keep it clean and for the customers coming in and out. And so there's actual testimony that a jury could consider that would say, this isn't just a restaurant that has some public sidewalk in front of it. This is a restaurant that's actually.
Okay, so the owner of the tiki bar says, whoa, there's a broken beer bottle there. I want to pick that up because I'm a good neighbor, but I'm also someone who cares about my patrons. Does that give rise, just because he undertakes the duty to protect his fellow human beings, does that give rise to a duty to police the sand for dangers?
Yeah, and you're starting to get into the Undertaker Doctrine, which does have duty. When you undertake a duty, that you have
I'm
you
not
have the
sure of
ability
that.
to
I'm
do
not
it.
sure that, someone, it's not like someone was having cardiac arrest and they went and okay, there's a good Samaritan law. Anyway, we're
Correct.
digressing, but, yeah, well, you're about to answer the question. I interrupted you.
Right.
But if I was a beach goer and I picked up a broken bottle because I cared about my fellow human beings, that wouldn't give rise to duty to me. That wouldn't be an Undertaker doctrine scenario. I'm not now responsible for the entirety of the beach.
No, but you would be, no, I think that's correct. The Undertaker doctrine says that whatever duty that you voluntarily assume, you have the ability, you have to do it non-negligently, I guess. So in your situation, if you pick up a bottle on the beach, but then you drop the bottle and it hits someone's foot.
Right, okay, so that means, okay, so
Then that, you could be sued for that.
what is non-negligently? If I'm a beach goer, then non-negligently would be I pick up a broken bottle and I throw it at someone, or I just drop it again, and then I'm not really being a good Samaritan at all. But in other words, that doesn't give rise, not doing the duty of undertaking to pick up the broken bottle negligently, or non-negligently, doesn't mean that hereafter I'm responsible for this plot of sand. And in the same way, why is the tiki hut owner, or why is Columbia, if they come out and they correct a paver, are they now? Why is if they don't forever do it, police it forever? Are they undertaking that duty negligently?
Well, I think that the premise is flawed, if I could say that, is because your premise is that they didn't have to do to begin with.
But now we're begging the question.
That Columbia,
They have a duty because they have a duty.
No, well, you're presuming that Columbia did not have a duty at all, and they undertook a duty.
Well, I thought that's what you were arguing.
No, that's not what we're arguing. We're
No,
arguing.
I thought that's your argument in response to my broken bottle.
I did, but that was
Okay.
just because you were getting the
Okay.
Undertaker doctrine. But our argument in this case, and it's always been, is that they had a duty to maintain that sidewalk. They had a duty to maintain the pavers for that sidewalk.
I want to unpack that a little bit. From whence does that duty derive? Like, what gives rise to that duty?
It gives rise to the duty from the body of law that we talked about. I talked about ingress and egress. That you have a duty as a restaurant, as business, to protect ingress and egress for your invitees.
So it's the question of control. It goes back to the.
It does.
Okay, so, but I want to make sure I understand that the duty arises from the control, not the other way around. Because it seems like a lot of your arguments actually flip it. A lot of your arguments seem to be along the line of, well, they did this duty, they cleaned it up, they monitored it, they did, and so therefore they had control. And I'm not sure that's
I
exactly.
think you're correct. The duty arises from the fact that they have control over the property. And so because they have control.
Over the ingress and egress.
Correct, and because they have control over that area in multitude of ways, they have a duty to maintain that area. That's where it comes from.
And I guess that's kind of my question, is that, the term control over it.
Right.
For better or worse, you're talking about it, you should do a fair amount of dirt balls. So I'm always wanting to know, okay, what are the rights?
Sure.
What can the property owner, first of all, what's the nature of their right? I mean, a property owner has a right of access to their property over public space, and you get at least one. So, I mean, I think I understand that aspect, that they have a right to have access to their property, which they have abundantly. But this seems like something different. This seems like something that, okay, you're bounded by a public sidewalk, you put a front door, people use the sidewalk to get into your business. Therefore, you have a duty to, well, yeah, see, again, I mean, you end up just going backwards. You have some kind of control over the ingress and egress portion of the sidewalk, but the dirt lawyer probably just keeps wondering, what is it you have? What does the Columbia have over that? What could they enforce?
Right, and I think, I mean, it's a great question to Judge Lucas, but I think at the end of the day, when you're talking about this, I kind of come back to what Judge Black put in the gas decision, is that those issues, possession, control, who had it, who didn't, where did it stop, where did it end? All those issues are not for the trial judge to determine. They're for the jury to determine. And
If
so-
there's a dispute of fact.
Yes, if there's a disputed fact, sure. And certainly there's a disputed fact in this case. We're saying that all these elements of
The
control.
plaintiff has to
are
do
there.
some evidence that there was control in order for there to be an issue of fact.
I would agree with that. And certainly I believe that the evidence established elements of control.
Let me take issue with one sentence in light of what you just, I think, conceded and perhaps other parts of your did. He said, a party owes a duty to invitees on adjacent land when the party exercises control or implied authority over that property by inviting others. And what I read from that sentence was that merely by the invitation, that confers on the inviter control or implied authority. But I don't think you meant that. I think that you would agree that it is invitation plus control, right? In other words, by inviting someone to, hey, come this way, walk this way, because come to my door and partake of my wares. You're not exercising control over the way. You have to have both,
Yeah,
right?
It does become, I haven't thought about it that way, frankly. And I do think that the case law, when you look at it broadly, does talk about that you really have, it has to be kind of a both situation. You can't, because if I'm in the middle of some building and I call my friend and say, hey, come on in this building, I've invited them, but I don't have authority to do that. But also I don't have the control over it, right?
You don't control the sidewalk.
I
So
think
why do they have control of this sidewalk?
Right, and now I do think that when you add in the element of the person who's doing the inviting is actually the person that is control over the property.
How do they control it?
They control their restaurant, they
No,
control.
the sidewalk with the paper.
That's that dual argument that we have.
Okay, those
You can
dual. So we know the city
you can have
controls it
control.
because they have an ordinance and they said, we maintain the sidewalk. However, if we notify you, you maintain the sidewalk. But how does the business control the sidewalk?
The business controls the sidewalk because it is the way to get in.
So that sounds like the argument that I just rejected for the sake of discussion, which is that merely by inviting, you've exercised control over the ingress and all points along the ingress and egress. But is that what you're saying? In other words, I just said, I posed two different conceptions of the analysis. One is that you need invitation plus control. And you're arguing, as I perceive this one sentence in your brief, which is to say that by inviting, you have exercised control.
Yes,
So that means that by inviting someone to the tiki bar, you've controlled the entire beach because the only way to approach your tiki bar counter is through the sand.
you have invited them to. I can understand where you're going, Judge, is that, the way you get there, right? I mean, but to me, in inviting and controlling the premises we're talking about control of the premises, meaning how you get there. It's not the route you take, it's the actual how you get in. And this is where we're talking about here. This is not a situation where this fall happened way down the line. By the way, I just want to meet, if I'm not out of
You're
time.
at your rebuttal time, so.
Okay, let me just say this one thing if I could. This question that you're asking actually came up, was the facts in the city of Naples case. The Joe Gass was not going to the restaurant where the papers were in front of them. She was just looking around to see what restaurant she was going to go to. So where
They had a contractual right to control that sidewalk by virtue of their contractual right to to sell food and allow people to dine on that sidewalk and to place sandwich boards on that sidewalk. So where is that in this case?
they put awning, they put the pillars on it, they put all.
So in
the
every
things that they
case in
were-
which somebody has an awning, and if we can't tie the injury to that little pillar, they now have control over everything under that awning.
It's not what I say, I think it's what the law says.
Okay.
Thank you, Your Honor. I'll reserve the rest of the rebuttal.
Good morning, Linda Klein here on behalf of Columbia. Trial court clearly got it right in this case. There were no disputed issues of fact related to ownership, possession, or control of the premises. And that duty, where there is no disputed issue of law, then it is a question of law for the court. I agree with a number of the questions from the panel as to basically a slippery slope concern here. if every business, simply by sweeping in front of it to make sure that its ingress and egress was pleasant to look at, immediately assumed the duty to then repair and maintain
Well, in
public
fairness
property.
to the facts of this case, the Columbia is more than that. I mean, I happen to be familiar with this area's sidewalk as well. I mean, they put up pillars, they put up all awning over it. I mean, they stake they put their property down on top of city property. Why is that enough to go to a jury to figure out whether or not, yeah, especially under our City of Naples versus Chops Bar and Grill.
Well, because I think that under this particular circumstances in this case, actually this reconstruction of the awning was done with a specific agreement with the city to encroach on the city's property. There was no additional agreement to do anything more than to maintain Columbia's own property.
So I want to understand, are you advocating, I mean, this issue seems to come up some about ingress, egress, public sidewalk, public way, somebody gets hurt, can you hold the adjacent landowner liable and negligence for not maintaining that? Are you advocating along the line of a strict, look at the property rights, just look at the property rights, and that ends the inquiry for the jury? Is that what you're advocating?
If you're asking me in every case, no.
So
Certainly
then
there's going to be,
How do we know when we look beyond whether or not there's an encroachment agreement, an easement, what have you, that gives rise to that?
well, I think it goes back to McCain and zone of risk, and there are a number of cases that I think both parties have
Saying
cited.
zone of risk, that sounds like, I mean, that could just be, look, you have the only way people are gonna come and go into your restaurant is by coming and going into the ingress, egress. That's a zone of risk, you recognize it, you assert control over it, you put an awning over it, you sweep it. That's all indicia of your control over the ingress and egress as a part of the zone of risk of doing business.
Well, no, I'm thinking in terms of those cases that say, a property owner can own a duty on property they don't own if they create something on their premises that affects that
You're talking about
property.
the insufficient parking cases where if you've got a nightclub over here and you don't have enough parking, but you tell people, hey, go park over there, then you assume a zone of risk when they get hit.
Correct, or you know, your Winn-Dixie, and there's a risk that there's, I don't know, paper bags that somebody can slip and fall on. And there's evidence that you do with this paper bag and had the opportunity to pick it up. That's something that emanated from the property and went on abutting property. That's not the facts of this case, though. There's
Yeah, well, I
nothing.
think if I understand your argument, is that the zone of risk was not created by Columbia Restaurant.
Correct, there's nothing, a Columbia Restaurant didn't have a flood that went out into the sidewalk so that somebody slipped and fell on. That would be, under those circumstances, yes, Columbia did something wrong on property that it owned or controlled, and that wrong that affected somebody on different property. That's not what we have here. There's certainly no facts in this case that say that the awning or the pillars of the awning or anything like that has anything to do with it.
And I get that argument, I get it about the zone, it's a question of, are you creating a zone of risk by virtue of what you're doing with property you have control over? But how do you distinguish the City of Naples versus Chops Bar and Grill case, where yes, there was some contractual right to use for the adjacent restaurant to use the portion of the sidewalk, but that really wasn't what gave rise to the accident at all.
In that case, it was actually the Naples code actually permitted the use of sidewalks for outdoor dining.
But again, that's not what created the zone of risk. It was pretty much an identical kind of injury as to what we have here, which is like there was just the sidewalk was uneven and somebody tripped on it. So it doesn't seem like to me that the Naples case really turns on that notion.
Well, actually, the Naples case, I think, turns on the notion that, that CHOPS had the ability to exercise control. And, I believe, with due respect to Judge Black, I don't necessarily agree with the city of Naples versus CHOPS case, or how broadly.
You know how it works though with subsequent
I understand, but I don't think that this is a case where the court meant to have a broad holding that whenever somebody is entitled to use the sidewalk for something, that necessarily means tag therein. And in this case, we don't have the ability. There's no contract, you know, there's no ordinance, there's
I'm
nothing.
stuck with what CHOPS says, we're bound by it, we've gotta follow it faithfully, and I just need your help, how do we better distinguish it along the lines of that zone of risk argument you're making, which I get and I appreciate, vis-a-vis the other cases that talk about what happens when when patrons get injured on property that doesn't directly belong to them. It is a function of zone of risk arising from the original property. I totally understand that, and I can read that along with you. I'm having a hard time reading that into CHOPS needs.
I think the distinguishing feature would be the Naples Code. That the Naples Code does imbue an abutting property owner with the ability to possess and control a portion of the exterior of their property, and to use an example that Your Honor indicated, presumably exclude someone from that portion of the premises on which there was a sandwich board, on which there was outdoor dining.
So let me get this straight, every restaurant in Naples on that street, could in theory put up, you know, the Bob's barricades in front there and say, yeah, you can use all the other part, but the ingress and egress part, no, we're not letting you use this part.
Well, I think under the code, it does.
It could.
But we don't have that code here. We don't have any duty in this case arising from an ordinance or code, except in the very narrow circumstances of the City of Tampa ordinance, which says when the city gives you written notice, then you have the duty. It would seem to me, if we had the duty all along, it wouldn't be so limited. And that indicates to me that the law must be that you don't have that duty, you don't have that obligation, except in those limited circumstances. It just simply makes no sense to require property owners to exercise control over property that they don't technically have control over, just to protect themselves. The law does not require a business or a person to assume a duty, and that is basically what the plaintiff is alleging here. And you go back to the beach example. How is the Columbia somehow liable to inspect and repair and maintain property that is clearly under the auspices of the city, and who is solely responsible to maintain and repair it, simply because they're sweeping the front of.
Well, they're not solely
property.
responsible. If the restaurant gets a notice from the city, it's the business's responsibility.
Correct, but in this case, since there was no written notice, then how can you put that burden on someone who doesn't possess or control the property? How do they have the right to do anything to
Well,
repair?
I think the question more discreetly is, does a jury get to decide that? Whether or not the Columbia had control over that portion of the sidewalk?
I don't think so. I think when you're talking about a duty, that is a legal issue. It's always been a legal
Yeah,
issue.
go back to the point that maybe a friend on the other side, you know how the jury instructions read. You can, in construing the scope of duty and a negligence claim, you can consider, and they go through kind of what the reasonable person standard, et cetera, why that wouldn't apply here.
I don't think it applies here because I think there has to be a certain minimum level of evidence on which a jury could base its verdict. The jury can't just simply say, well, I think the restaurant should have done that, and that's basically what they're arguing here. That would basically put premises liability law, you know, in the entire hands of a jury, depending on how they feel. And that's not how the law as it exists can be construed. I think the City of Davis case is distinguishable based on the code. And I think under the circumstances, in light of the undisputed evidence in this case, there simply was insufficient evidence of any exercise of possession and control by which Columbia assumed a duty it doesn't otherwise have under the law. If the court has no further questions, I'll rest of my brief. Thank you very much.
Thank you, Council. We have about 3 minutes.
Well, thank you, Your Honor. I was actually gonna ask how much time I had, because I blew right in 5 minutes. I'm reading from the City of Naples case. It says, and it talked the opposite in that case about lease agreement and things of that sort. It says, despite a contractor party who exercises control over property may have a duty to maintain a premises. Oops, and it just went away from me. I'm sorry, there it is. In a reasonably safe condition. Moreover, a tenant's ability to manage and control an area is a question of fact for a jury to decide. It can't be more clear than that. And when we're talking about, and to go to the instruction argument, I think that there are sort of two sides to a duty when a jury gets it. A jury gets, there is the side to a duty to see, is there a threshold duty, right? Do I have a duty to another person? Does a business have a duty to me? What if I was never even part of the business and I just, tripped at my house? Does Columbia have a duty to me? No. There's nothing that's the first part. That's what a judge typically decides. But if there's evidence that then goes to, okay, how does that duty, what was the parameters of that duty? How far did it go? Does that duty say they have to maintain the sidewalk? That's what the jury gets to decide.
What's the duty? So you have to have adduced evidence of a duty.
Yes.
What's the evidence of a duty?
The evidence of the duty is that,
In order for there to be a fact issue.
right, and the evidence of duty comes from what I was talking with Judge Lucas's control. If you have control over a piece of property.
What
Then you have to
differentiates the control of the porters to relocate a paver for the benefit of passersby from me as a good Samaritan?
It doesn't have to be that specific. You don't have to, there.
Well, that kind of goes with what opposing counsel says, you can't allow a jury to, if there's no evidence that there is, that we have to determine. It does have to be specific because the trial court said there was no issue of fact, and you are here to convince us that there's an issue of fact. So how is the ability of the porter who works for Columbia to relocate a misplaced paver different than the passersby who may, as a good Samaritan, do the same?
That's not an issue for the judge to decide. That's my whole argument. The judge cannot decide that I think that porter actually didn't have the duty to do that. Because that
was the evidence that the porter had the duty.
That's what the gas case talked about. The gas case talked about a lease agreement that said specifically, that didn't say in it that you had to maintain that sidewalk.
But
This court said that didn't matter. It doesn't matter because of the fact that.
What did matter was an ordinance that allowed, I don't think it's much of a difficult inference to draw from the ordinance in Naples that said you are allowed to, put tables out there and serve food that you could exclude. You have control of the property. Plop a table down, serve them food. You have to make a reservation, perhaps. I don't know. But the point is that is control.
Well, it's true, but also it is an element of control. We're talking about elements of control. One of the other elements in gas that this court specifically said was the fact that the restaurant sent people out to clean it. To clean out that sidewalk, not that they sent the people out to remove pavers, to put the pavers back, that they sent them to clean it. That was one of the elements of control that this court found.
So anybody
was
who
sufficient for
sweeps the walk in front of his or her business now has a duty based on the control that they have over how much dust is in front of their doorway.
I'll give you the last word and then you need to wrap it up.
I don't think it's that final point. I think that at the end of the day, we're sort of talking about how far does it go? Trial judges under the law don't determine that. Juries do. And under all of the law that you've seen here, that is purely a jury question. And so for that reason, the trial court went beyond what he was supposed to do. And he should have denied the summary judgment, and we're asking the court to reverse his summary judgment so that the jury can determine that.
Thank you both, well done.